Good day, everyone, especially to you, Dr. Rhea Kiber. My name is Jeah, and today we're going to talk about the chapter 4, which is the law on partnership and corporation.
But before anything else, I will be providing to you the topic outline and the objectives for this lesson. So first, we do have the introduction to partnership and corporation law. Next is the partnerships, case study on partnerships, corporations, distinction between partnership and corporation, formation and organization of corporations, and government requirements for partnerships and corporations. And for the objectives, first is to understand the fundamental principles governing partnerships and corporations. Next is to differentiate between partnerships and corporations based on legal, financial, and managerial aspects. Also, to analyze the essential requisites and classification of partnerships. To evaluate the legal advantages and disadvantages of forming a partnership or corporation. To comprehend the legal procedures and government requirements for establishing a business entity. To apply legal concepts to real-life business cases and resolve partnerships disputes, to recognize the role of regulatory bodies in business operations, and to develop a practical understanding of corporate and partnership laws for future entrepreneurs and business professionals.
So, what is partnership? A partnership is an association of two or more persons to carry on as co-owners of a business for a profit. But it does not include religious associations, conjugal partnerships, and others of a similar nature because a partnership is defined by law, refers only to associations with the purpose of which is to obtain profits to be distributed among the partners. So that is partnership, or the definition of partnership. And partnership contract is based on trust and confidence with the delectus personae, which means wherein no one can become a partner in a partnership without the consent of all the partners. So with consent, it comes with confidence and trust with each other. There are two essential requisites of partnership. First, an agreement to contribute money, property, and industry to a common fund, and this is complied with if each one of the partners brings or is obliged to bring something to the partnership, and that which is brought becomes common property. And second, its intent to divide the profits among themselves. This is complied with if partnership is established to obtain profits, if profit must be common to all the parties, and profit or loss must be divided among the partners. So there are also advantages and disadvantages of having a partnership. So let's go tackle first the advantages of forming a partnership. First, it is easy to form. Second, it improves growth possibilities. And third, it has a freedom for or from bureaucracy. So it means that it could mean reducing restrictions or giving more independence so that they can make decisions without too much political interference. Or in simple terms, it's about letting bureaucrats do their jobs with fewer obstacles. Next are the disadvantages of forming a partnership. First, its instability. Second, difficulty in obtaining large sums of capital. Third, firm is tied to the acts and judgment of one partner as agent. And fourth, difficulty in serving partnership ties. So we also do have the classification of partnerships. First, according to subject matter. And for that, we do have universal partnership. So it is where all of the partners contribute all of their properties to the common fund and speaks of no particular purpose or subject matter. But as long as the purpose in forming a partnership is to obtain profits and is not contrary to law, morals, public order, and public policy. And nowadays, seldom if none do you experience business establishments forming a universal partnership. And also, we do have particular partnership, which has for its object determinate. And second, we do have particular partnership, which has for its object to determinate things, their use of fruits, or a specific undertaking, or the exercise of a profession or vocation. Next category is we do have the according to liability. So first of it is the general partnership. It is composed of general partners where liabilities extend their personal properties. And we also do have limited partnership, which is usually attached LTD or limited at the end of the company name. So it is one formed by two or more persons having as members one or more general partners and one or more limited partners, where the liability of the latter to third persons is limited to their capital contribution. And next category is according to duration. So we have a partnership for a fixed term. It is one in which term of its existence has been agreed upon expressly as when there is a definite period. So the expiration of the term thus fixed or the accomplishment of the particular undertaking specified will cause the automatic dissolution of the partnership. So next is we do have the forms of partnership. A partnership can be in any form, even if not recorded at the Office of the Securities and Exchange Commission, except when it is stipulated, and when immovable property or real rights are contributed, in which case there must be a public instrument to which is attached an inventory of the immovable properties and signed by the parties, otherwise the partnership is void. And in case of limited partnerships, the parties must sign and swear to a certificate which shall state among the others the name of the partnership. The name of the partnership, adding the word limited and the character of the business. And file for record the certificate in the Office of the Securities and Exchange Commission. Failure to comply with the foregoing formal requirements will only make the partnership a general partnership. So for this one, I'm going to be providing to you a case study which we will go ahead and analyze for this case study. So for that, I'll be providing to you the background of this case study first. So the background of it is sometime in June 1986, Fernando Sandoval and Naomi Reyes were introduced to each other by Melly Zayobal regarding a lending business venture proposed by Naomi. So it was verbally agreed that Fernando will act as financier, while Naomi and Melly take charge of the solicitation of members and collection of loan payments. So the venture was launched on June 13, 1986, with the understanding that Fernando would receive 70% of the profits, while Naomi and Melly would earn 15% each. And in July 1986, Naomi introduced Cesar Santos to Fernando. Cesar Santos, as Chief Financial Officer of Discovery Hotel and Suites Incorporated, sought short-term loans for the members of the corporation. In this regard, Fernando Sandoval and Cesar Santos executed an agreement providing funds for the members of Discovery Hotel and Suites. Under the agreement, Discovery Hotel and Suites, represented by Cesar Santos, was entitled to 1.31 commission per thousand paid daily to Fernando Sandoval. Naomi kept the books as representative of Fernando Sandoval in doing business for Discovery Hotel and Suites. Fernando Sandoval and Naomi Reyes later discovered that their partner Melly engaged in the same lending business in competition with their partnership. Melly was thereby expelled from the partnership. So there are two main questions for this. First, who are the partners in the lending business venture? How are they classified? Second, was Fernando and Naomi correct in expelling Melly from the lending business venture? So we're going to go through it and we're going to be providing a legal opinion upon this matter. So to answer the first question, the partners in the lending business venture are Fernando Sandoval, a capitalist partner who acted as financier of the partnership, and Naomi Reyes, an industrial partner who contributed services by taking charge in the solicitation of members and collection of loan payments, and also Melly Zayobal, also an industrial partner who contributed services by taking charge in the solicitation of members and collection of loan payments. And next, for the second question, if Fernando and Naomi were correct in expelling Melly from the partnership. So the answer is yes. Fernando and Naomi were correct in expelling Melly from the partnership. An industrial partner like Melly A partner who merely contributed industry or services to the common fund cannot engage in business for herself. Otherwise, the capitalist partners, like Fernando, may exclude her from the firm. That would be for the case study. So next, civil interdiction. It is an accessory penalty for the commission of an offense, which deprives the offender during the time of his sentence of the rights of parental authority or guardianship, either as to the other person or property of any ward, of marital authority, of the right to manage his property, and of the right to dispose of such property by any act or any conveyance inter vivos. Insolvency. It is a financial condition in which one is unable to meet his obligations as they mature in ordinary course of businesses, or in which one's liabilities exceed his assets at any given time. So I will be providing to you another case study. And I'll be providing to you a background of it. So on July 25, 1984, LJ Villa, Carmen Jose, and Jess Jose formed a partnership with a capital of 750,000 pesos for the operation of a restaurant and catering business under the name Aqua Food House and Catering Services. So Miss Villa was appointed the general manager and Carmen Jose as operations manager. And Donald Camses joined as a partner in the business on September 5, 1984. His capital contribution was 250,000 pesos, and after Jess Jose withdrew from the partnership on January 15, 1987, his capital contribution of 250,000 pesos was refunded to him in cash by agreement of the partners. And on February 14, 1987, the restaurant was closed down without the knowledge of Mr. Donald Ramses. Upon the closure of the restaurant, Donald Camses was demanding for the return of his capital contribution of 250,000 pesos. So when was the partnership dissolved? Is it possible for Mr. Donald Ramses to be entitled for the amount of 250,000 pesos, which is the return of his capital contribution? So we're going to go ahead and talk about that questions and answer those ones with a legal opinion. So for the legal opinion, the partnership was dissolved on February 14, 1987 when the restaurant was closed, assuming that LJ Villa and Carmen Jose acted in good faith in closing down the restaurant. It appears that the partnership that was formed is a partnership at will since no definite term was stated in the contract of partnership. Hence, the partnership was dissolved and on the basis of Article 1830, letter B of the Civil Code of the Philippines, and on the other hand, Mr. Donald Ramses cannot be entitled for the amount of 250,000 pesos. Well settled is the rule that a share in a partnership can be returned only after the completion of the latter's dissolution, liquidation, and winding up of the business. Since it is a refund that must be shared by the partners, the amount to be refunded is necessarily limited to its total resources. So in other words, it can only pay out what it has in its coffers, which consists of all its assets. However, before the partners can be paid their shares, the creditors of the partnership must first be compensated. After all the creditors have been paid, whatever is left of the partnership assets becomes available for the payment of the partners' shares. Evidently, in the present case, the exact amount of refund equivalent to Mr. Ramses' share in the partnership cannot be determined until all the partnership assets will have been liquidated and, in other words, sold and converted to cash, and all partnership creditors, if any, paid. So next, law on corporation. But before anything else, what is corporation? What really is corporation? So a corporation is an artificial being created by operation of law, having the right of the succession and the powers, attribute, and properties expressly authorized by law are incident to its existence. And the right of succession, it means that a corporation has the capacity to exist regardless of the transfer of interest or shares of stock. So there are multiple kinds of corporation. First is a stock corporation, one which is a capital stock divided into shares and is authorized to distribute to the holders of such shares or dividends, or allotments of the surplus profits, like retained earnings on the basis of the shares held. So, a stock corporation is organized merely for profit. So, the governing body of a stock corporation is usually the board of directors. And next is we do have the non-stock corporation, where no part of its income is distributable as dividends to its members, trustees, or officers, subject to the provisions of the Code on Dissolution. So a non-stock corporation is one not organized for profit. So the governing body is usually the board of trustees. It is somehow contradictory to stock corporation, which is governing is the board of directors. So for non-stock corporation, the ones that's governing are a board of trustees. Next is we do have the corporation de jure, a corporation organized in accordance with the requirements of law. Next is de facto corporation, a corporation where there exists a flaw in its incorporation. Next is public corporation, which one formed or organized for the government of a portion of the state. So it is created by its own charter for the exercise of a public function. Example, barangay, city, or municipality. Next is private corporation, which is one formed for some private purpose, aim, or end. It is created by incorporation under the General Corporation Law. This includes a government-owned and controlled corporation with an original charter and quasi-public corporation, a private corporation performing public functions. Next is corporation sole, one organized for the purpose of administering and managing as trustee the affairs, property, and temporalities of any religious denomination, sect, or church. So, in this corporation, there is only one incorporator. Next is eliminatory corporation. So one organized for a charitable purpose. So it's more for like charities. Next is a domestic corporation, a corporation formed, organized, and existing under the laws of the Philippines. So it is within the Philippines only, from the word itself, domestic. And lastly, the foreign corporation, a corporation formed, organized, or existing under any laws other than those of the Philippines and whose laws allow Filipino citizens and corporations to do business in their own country or state. So next, I will also be providing to you the advantages of a corporate organization and disadvantages of corporate organization. So for the advantages of a corporate organization, first, we do have the strong separate judicial personality. Next is the limited liability to investors, free transferability of units of ownership, centralized management through the board of directors, professionalism, and easier to sell small amounts of stock to raise capital. Next is we do have the disadvantages of a corporate organization. First, extensive government regulation. Next is double taxation. Third, its activities are limited by charter and various laws. So next is distinction between a partnership and corporation. So what is really the difference or the distinction of a partnership and a corporation? So I will be explaining to you so that we can really understand what really is a partnership and what really is a corporation. So a partnership is created by the agreement of the parties, while a corporation is created by law. And a partnership is a business owned by two or more people who share profits, responsibilities, and liabilities. And if the business incurs debts, the partners are personally responsible. Whereas, in contrast of a corporation, it is a separate legal entity owned by shareholders, meaning that the business itself is responsible for its debts, protecting the owner's personal assets. So, for partnership, it has a responsibility or like a personal responsible, whereas for the corporation it's the business entity itself, not a personal responsibility. And also, a partnership is typically easier to set up and manage, but it may dissolve if a partner leaves. Meanwhile, a corporation continues to exist regardless of ownership changes and is managed by a board of directors. In short, a partnership involves shared responsibility and risk, while a corporation provides limited liability and long-term stability. So next, steps in the creation and organization of a corporation. First is a promotion. Second is incorporation. Third, formal organization and commencement of the business operations. So next, here are the government requirements in doing business as a partnership or corporation. For requirements for registration of business name under DTI, or the Department of Trade and Industry. So first, for partnership, it should have articles of partnership, birth certificate of all the partners with their 2x2 pictures. And for corporation, articles of incorporation, bylaws, certificate of incorporation, birth certificates of all the incorporators with their 2x2 pictures. And also requirements for acquiring a business permit with the city or municipal mayor. First is barangay clearance. Second is certificate of registration with the DTI. Next is articles of partnership or articles of incorporation and bylaws. And lastly, the payment of fees. It is depending on the capital stock or amount of capital declared. Next is requirements for registration of business under the Bureau of Internal Revenue. It is to acquire a tax identification number, also business permit from the local government unit concerned, and certificate of registration with the DTI, articles of partnership, articles of incorporation and bylaws, and a 500 pesos annual registration fee. And lastly, requirements for registration of the Social Security System or SSS. To acquire an SSS number and PhilHealth number, also business permit from the local government unit concerned, certificate of registration with the DTI, and articles of partnership, articles of incorporation, and bylaws. And that would be all for my report. I hope you have learned something. Thank you so much for listening and have a great day.